Good morning and welcome everyone to Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. I guess I shouldn't just say good morning. I should say good afternoon. And I should also say good evening to some of you joining us from across the pond. Thank you everybody for being here. I see a lot of familiar names, Shy Gal and Melissa Loves True Crime and Joy W. Thank you so much. And a lot of new names. So I'll introduce myself. My name is Joshua Ritter. I am a former LA County district attorney. I was a prosecutor for 10 years. And then I went into private practice as a defense attorney. And I've been a defense attorney for nearly as long. And we started this channel with the goal of trying to give you a perspective from both sides of the courtroom. And so we hope that we do that. So thank you so much for being here. Hello to everyone who's also watching us on Facebook. That's a brand new thing. Not brand new, but something we've been trying, and we've been getting quite a few people to check in from Facebook. So please hit the like button, hit the subscribe button. If you haven't already, please say hello. Tell us where you're from. It's always incredible to see this growing community that we have that's actually worldwide. So thank you so much. And hello to Grizzly joining us from Switzerland. So what is it? Let me guess. 6 p.m. there? Almost? I don't know. I might be right. I might be close. Put it to you this way. It's a time that Gisela should actually be awake rather than in the middle of the morning, which I usually am talking to her. Anyhow. This is going to be fun today because you guys really showed up and you showed out and you left us a lot of great questions. And again, I say this every single week, but I'm absolutely amazed by the wide range of questions that we have. A lot of interesting topics for us to jump into. We'll get through all of these and then stay to the end because we have some announcements for you guys. But let's go ahead and jump into our first question. And we are going to pray that the audio is working on all of this stuff. I'm going to make double check I'm doing this all correctly. And then Kaylin's going to yell at me because I mess up her plan. But I hope I got this right, Kaylin. All right. No, not hearing it. Hold on. We'll try this again.
Hey, Josh and crew. This is Kat Cass from Washington State. I've been a longtime follower since True Crime News, the sidebar. I was wondering if you heard about the Whitefeather Lantz case out of West Virginia. And I was wondering what your thoughts were on how the defense defended them and just how outrageous it was calling the shed like a clubhouse. Anyway, thanks for all you do. See ya.
Thank you so much, Chaotic Cast, for kicking us off from Washington State and for being a longtime supporter. That she's referencing True Crime News, the sidebar, which is another podcast that I've been doing for a long time over on True Crime News's channel. So thank you so much for following us over here to Courtroom Confidential. The Whitefeather Lantz case was not a case I was familiar with, but it is a incredibly tragic and horrific case. And so let's get into it a little bit. So thank you, Cass, for having me do a little bit of research on this one because I had not heard about it. But we're talking about a case out of West Virginia where Jean K. Whitefeather, you see there, along with Donald Lantz, who I believe is her husband, they had adopted 5 Black children, and I believe they were all siblings. And they were found guilty in January of the following things: forced labor, human trafficking, child abuse and neglect, and civil rights allegations or violations for racism. Whitefeather is looking at 215 years in prison, and Lantz is looking at 160 years in prison. The children were ages 5 to 16 at the time when these crimes were uncovered, and we don't know how long it had all been going on for. But it's It's an absolute house of horrors type situation. They had been using these children essentially nearly as slave labor. They had been locking them in a shed, and that is the shed that Cass was referring to. There you see a picture of it there. That's where they found some of the children when first responders actually arrived, locked inside of this shed, sleeping on the ground, sleeping on like a shelf inside of the shed where you easily could have fallen from. Some of them didn't have shoes. Their clothes were filthy. They were malnourished. They had been enduring all sorts of extreme punishment, things like being made to stand for hours with their hands on top of their head so they couldn't even fall asleep as they were standing. Forced labor. They were extremely malnourished, something to the point where they were allowed 1 or 2 peanut butter sandwiches per day and a couple of glasses of water. And then they were subject to all sorts of, on top of the physical, there was emotional abuse. They were using racist language against them. It's absolutely, it makes your mind spin that something like this is taking place in this day and age. And it, thank God, became uncovered. I don't think it was one of those situations where one of the kids escaped. I think it was one of those situations where somebody made a phone call, like there's something bizarre happening over here on this farm. And Cass's question has more to do with what my thoughts were on the defense. The defense made the arguments that, like, listen, and I'm going to say their arguments and not say that I agree with their arguments. Their arguments were, listen, these folks were overwhelmed. These children had mental and behavioral issues, and they were basically doing the best that they could. And this is a quote from the defense. These are farm people that do farm chores. Now, I say all of that, and I'm sure that's making your stomachs turn, and it makes my stomach turn. And there's no excuse for this behavior. But to answer Cass's question, what do I think of the defense saying that? I think sometimes defense attorneys have to put on a defense. And you cannot stand there and say, I agree. I agree with the prosecution. This is horrific. I agree we should take my clients and throw them in prison and throw away the key. The defense in this case, Canine Lover says, I don't buy their defense. I don't either. I don't even think the defense attorney buys their defense. But somebody's got to stand there and make the arguments. These people, for our system to work properly so that we can all feel that justice has been adequately served, some sort of defense needs to be put on. And some unfortunate soul needs to stand up and make an argument for these people. So when you have these situations where it is, indefensible, you're left with arguments like this. You're left with arguments like, oh, they were overwhelmed, or this is just farm people and they're just doing kind of farm chores. And you city folks don't understand all of this. And that shed, and apparently this was part of the argument, that shed wasn't a punishment. It was like their clubhouse. All of this stuff is obviously disgusting. I imagine all of it was difficult for that defense attorney to say. But this is the job of a defense attorney sometimes. I have the luxury of being a defense attorney who can decide which cases I take and which I don't. But there are situations where, as a defense attorney, your job is to zealously advocate, and sometimes that puts you in a position where you're making awful arguments. Now, some defense attorneys, I think, enjoy this. Some defense attorneys don't sheepishly go into their job. They embrace these moments. And I don't know if that's what was happening here. As Afton says, everyone is entitled to a defense. So yeah, I think lots of times we see these horrific cases and we start to point some of our anger and disgust at the defense attorney. And I'm not standing up for defense attorneys, but I am a little bit right here because the defense attorney is the only one with their mouth open. And the two defendants are just kind of sitting there sheepishly. And it's the defense attorney that actually has to make these arguments. But it's important, I think, to remember they're not the one that did it. They're just the ones that unfortunately got tasked with the job of trying to defend this person. So if you guys haven't heard about that case like me, it's well worth checking out. It's just a horrific case. And thank God these children have now been rescued. And thank God they are now no longer suffering from that, and hopefully getting some therapy and help and try to recover them for what they had obviously been through. Maureen says, have you ever been on the public defender list? No, I have not. I went straight into private practice. So I am public defenders, by the way, they are an entirely different animal. They have to take every case that's assigned to them. They don't get the luxury of saying no. So lots of times they are put in the position of defending horrible, horrible people for horrible, horrible things. And I'll tell you, a part of me applauds them for doing it, because they believe in the system, and they believe that everybody deserves a defense, and they stand very strongly on their principles, and that sometimes can be really, really tested. But thank you, Chaotic, for that, calling us from Washington State. I'm going to try to keep track of everywhere that we've visited today. All right, moving on. Do I need to? No. Okay. She's telling me don't touch anything. All right. We'll see if this works.
Hi, Josh. This is Janet calling from Boca Raton, Florida. In my old age, I've become a crime watcher. It's a great hobby, along with mahjong and bridge. But I want to talk to you about the Adelson case. It's a heartbreaking case. Poor Dan Adelson was brutally killed. My question is, assuming that, what's the son's name that just got, Charlie is in prison for life, and he has some appellate cases. If his appellate cases don't work, do you think he might make a deal by throwing Wendi under the bus? I mean, after all, he has a little 4-year-old boy. He might want to be able to, at some point, end his sentence if he makes a good deal. Thank you. Enjoy your show.
Thank you so much, Janet from Boca Raton. Oh, Wendi Adelson. It is so funny. You cannot talk about Dan Markel and the Adelsons without somebody saying, what about Wendi? In fact, our friend Jay, who changed his name on his channel now. I think it's Jay Brocious or something clever like that. But he had a Twitter account where he would tweet. I don't know if he still does it. He would tweet every single day what the date was. This is April 6th, 2025. And Wendi Adelson, Jabronius. It is April 6th, 2025. And Wendi Adelson has still not been arrested. And it is funny because it's, here we are on this case. Dan was murdered on July 18th of 2014. 5 people have been charged. 4 of those people have been convicted for his murder. And there is one outstanding person that seems to be at the center of all of this, that everyone keeps on wondering, when is this person going to see their comeuppance? When is Wendi Adelson, who was Dan's wife at the time, who, if you are not familiar with this case, the whole case centers around the fact that Dan and Wendi were going through this awful, awful divorce that had a lot to do with child custody, a lot to do with where the children would live. He was living in Tallahassee. She wanted to live in South Florida with her parents. She didn't like the idea that that's where he had found his work and his career. And the state's theory, and that is proven to be true in every single case that they've brought, is that Donna, likely the one pulling the strings, had orchestrated the murder of Dan Markel through Charlie Adelson, through the use of some intermediaries and hitmen, and had him killed, all so that Wendi could benefit by having her children with her in South Florida. So if all of that is true, how could Wendi possibly not be in on it? And it begs the question, why hasn't she been arrested? If you've been following this case closely, you also likely feel that there is sufficient evidence to bring charges against Wendi. I'm going to be very careful about the way I speak about this, because she has not been charged. She has testified during more than one of the trials. And there has been no statement from prosecutors about what they intend to do with her. I would normally say in a case like this, they're not charging her because they would not wait this long. We're talking about 11 years now since the murders. They would not wait this long to bring charges. But that's not how these prosecutors operate. They have waited a while. They first brought charges against the hitmen. Then it was Catherine McBanois, who was the girlfriend of Dan Markel. Then they brought charges against Dan. Then they brought charges against Donna. In fact, Donna wasn't even arrested until after Charlie was convicted. So you have this kind of very patient, very systematic way in which the prosecution seems to be going through this entire case. So maybe it is that they're waiting for all of this to be said and done before they bring charges against Wendi. But that's not really Janet's question. Janet's question was, if Charlie, who we're looking at there, exhausts all of his appeals, might we think that he'll turn against Wendi? And that's interesting because you would think traditional kind of logic would say, no, if he's got a card to play, he's going to play it now, right? If he's got some sort of bargaining chip with the government, hey, I can give you the goods on Wendi. I can tell you what she did, how she was involved, how you can actually indict her. But I want some sort of relief on my sentence. I want some sort of cap on how many years I'm going to serve. I want some sort of benefit for all of this. You think he would have played that card at this point? I think Janet's question kind of explores a different idea. What if he exhausts all of his appeals? And by the way, by the time he does, we're probably talking several years down the line, maybe, upwards of 10 years down the line, when he exhausts all of his possible appeals. And what if he's at the point where he's just got nothing left and he finds himself sitting in prison for the rest of his life? And he goes, you know what? I wouldn't be here if it wasn't for Wendi. So why should I be here all alone? Who knows? The answer to that question, Janet, is who knows? It could be that far down the line, he says, yeah, I'd like to say something about Wendi. And by the way, don't be surprised if they actually bring charges, even if it is several years down the road, because there's no statute of limitations on murder. And if he's willing to talk, and that was the final piece that they were missing to bring charges, then, who knows? Stranger things have happened, and they all seem to have happened in this case. But great question. Squinting Cat says, what about Harvey? If Charlie, Donna, and possibly Wendi, why does Harvey get left out? It's another great question. Harvey is Donna's husband. The only thing I'd say about Harvey, though, is if they were going to arrest Donna, you would have thought they would have arrested Harvey at the same time. And to me, it makes zero sense. They would not have done that. And I just think that, eventually there's a great difference between our level of suspicion and the level of probable cause that prosecutors need to bring charges. Prosecutors should, they don't always do, but they should only bring charges when they feel they can prove it beyond a reasonable doubt. Beyond a reasonable doubt is the highest standard we have. And there's a lot of room for suspicion before you get to beyond a reasonable doubt. So it could be that they do believe Harvey is involved, and they do believe Wendi is involved, and they have great suspicion about both of them, but they don't believe that they have enough evidence beyond a reasonable doubt, and that's why they haven't made the decision to arrest them before now. But great question, Janet from Boca Raton. Appreciate you very much. All right, let's move it along here. Let me see if I'm doing this right. Yes.
Hi, Josh. This is Pam from Michigan. I feel like I'm calling you all the time, every week. Love your podcast. I learn so much from it, and I get lots of information and makes me think about things that normally wouldn't think about. So my question for you is, I don't know if you would know the answer to this. So about 15 years ago, 2010, there were 3 boys missing from Michigan, the Skelton Brothers. They were never found. The father is serving time in prison. I think he's getting out soon. Not for murdering them, but just for not releasing any information. He said he gave them to somebody for safekeeping. The mom has declared them legally dead at this point. My question is, can they bring murder charges against him now that they're declared legally dead when he either gets out of prison or while he's still in prison? I've always wondered, I've always read about that being in Michigan in the general area where they're missing from, and always wondered about this case. It's very sad. So anyway, that's my question. Love everything you guys do. Keep up the great work. I'll probably call again next week. Thanks.
Thank you so much, Pam from Michigan. And don't ever apologize for calling every week. I hope that you do, and I expect to hear from you next week. So thank you very much. This is another case I was not familiar with. The horrific case of the Skelton brothers. There they are, beautiful, beautiful young boys, and they're missing, and they're gone, and they've now been declared dead. And it's just an awful, awful tragedy, but it is made even more horrific and nightmarish by the idea that their father is likely the person responsible for them being missing. Can we give a quick and huge shout out, by the way, to Kaylin for always being so on top of all of the graphics and putting together all these pictures and everything, so I can just jabber on and she takes care of showing you guys all the images. I really, really appreciate it. So the Skelton brothers, there are Andrew in their picture, Andrew, age 9, Alexander, age 7, and Tanner, age 5. And they have been missing since November 26 of 2010. They were last seen in their backyard in, I'm going to butcher this name, but I'm pronouncing it Morenci, Michigan. I hope that's right. Anybody from the Michigan area, tell me if I'm wrong. And though they were missing, they were not officially declared dead until November 26 of 2015. And in fact, though there was a request that their death date, the date of their death, actually be November 2010, Michigan law says that you cannot legally declare someone dead until 5 years has passed without having heard from that person. Very interesting. Each state kind of handles this differently. Black Witter says their little faces are breaking my heart. I couldn't agree more. Each state handles this a little bit differently on how they determine whether or not to officially declare someone dead. Here's just some of the background and facts of the case. Skelton, John Skelton, the father, apparently attempted to kill himself soon after they went missing. He told police that he gave to the boys to a woman by the name of Joanne Taylor and told her to return them to their mother. Investigators believe Joanne Taylor does not exist, that is a made-up person, that it's a fictional woman. Part of this is based upon the idea they've never been able to track down this person. Other part of it is based on the idea that he had apparently recently created an email account for Joanne Taylor before the boys went missing. And that account, that same person, that same identity had interacted with their mother, whose name is Tanya Zuvers, on one of these kind of mother chat groups, and had been communicating with her in some sort of sick, I don't know what he was trying to accomplish, way of creating this personality that he was then going to use as like an alibi or an excuse as to, this is the person that he gave their beautiful young baby boys to, and it's her fault that they're now missing. Well, as with all of these things, the police do some more sleuthing. They do some more investigation on his computer. They find out that he had Google searches for rat poison. They found that he had Google searches for how to break a neck or spine. The more you find out about this, the more that this man sounds like an absolute monster. So here's where things stand. He was arrested and found guilty of their kidnapping and eventually found guilty of unlawful imprisonment in July of 2011, but not murder. He's serving 15 years for that. he's soon to get out for that. And so the question becomes, this is Pam's question, whether or not they will bring charges for murder now that they've been declared dead. And I'll get to that. But first, I want to read you something that the judge said in this case to maybe give you an idea of where things stand. The judge says the presentation of evidence, however, does not present clear and convincing evidence that John Skelton murdered his children. The information provided at this time provides ample opportunity for speculation and theories, but to make such a finding, the court would only be joining those voices offering such speculation and theory given the lack of information. This is a statement that the judge said at the time of declaring them legally dead in March of 2025. But to get to Pam's question on whether or not this now change in circumstances, this declaring them officially dead legally, will turn this into a murder investigation. The answer is no. The answer is investigators have been investigating this as a murder investigation from day one. Okay. Many times when you have a missing person, the officer assigned, the investigator assigned on a missing person is likely a homicide investigator. Not always, but many times, especially when you're talking about missing persons of children under suspicious circumstances, all three of them disappearing at once. You are likely treating this from the get-go as what may be a homicide investigation. The fact that they were not legally declared dead is a legal function, is a legal, that's for purposes of death certificates and life insurance and everything else. It really does not dictate and guide the police investigation. In other words, to be more simple and direct about it, it's not like they can all of a sudden, they need to wait for an official declaration of death before they can start a investigation on murder. They've been investigating this, I am sure, as a murder case since shortly after those boys disappeared back in, what was it? I said this before, 2010. So we're going on 15 years now. So where does that leave us now? Well, it sounds like whatever information they've had for the past 15 years has not been enough to bring charges. And if what that judge is saying, he doesn't even feel that it rises to the level of clear and convincing. Clear and convincing is actually a legal standard of proof, and that's less than beyond a reasonable doubt. He's saying it doesn't even rise to that level. That's just that judge's assessment. I don't know if the judge knows everything that the investigators have done and everything that they've learned. To me, there seems to be ample circumstantial evidence of his involvement, but for whatever reason, investigators have decided not to bring murder charges. Now, that could all change, obviously, especially, I would say, even if he gets released. Because a released person from prison is going to start talking to people. And an unstable, twisted mind like this, I imagine, cannot keep their mouth shut for very long. And it may be just something as simple as him saying something alluding to those murders to someone, somewhere, someone being willing to come forward that tips this case. But I will join in all of your frustration that I don't get it. When you've got a guy who is doing those types of Google searches, he's the last one to have been with the children. He says he gave them to a fake person. They go missing. It's like, what are we waiting for here? I don't get it. JC Broadway says, haven't there been no body cases brought on less than that? I agree with you. I don't get it. I don't know enough about this case to give a complete assessment of it. And I hope that the investigators in Michigan are taking it seriously. And I have no reason to doubt that they are, but it really, the more I began to read about this, the more I began to get frustrated and confused as to why they had waited this long, why they felt they didn't have enough. To me, even the short little tidbits I've given you here, I feel like that makes a pretty solid case. but we will see, and we'll follow this one. Thank you, Pam from Michigan, for giving us a heads up on that. All right, let's move along here. Great stuff, guys.
Hi, Courtroom Confidential. This is Christine from Ontario, Canada. There are so many differences between the Canadian and American judicial systems, but the biggest contrast I've noticed is how our countries handle life imprisonment. In 2022, the Supreme Court of Canada ruled in R versus Bissonnette that it is unconstitutional to sentence an offender to a term longer than 25 years without parole eligibility. It was deemed cruel and unusual and a violation of the Canadian Charter of Rights and Freedoms. It was determined that the offender must not be presupposed to be beyond redemption and rehabilitation. I'm curious, as an American and someone who has worn the hats of both prosecutor and defense attorney, what are your thoughts on Canada's ruling on life imprisonment? Thank you for taking my question, and I look forward to hearing what you have to say on Sunday's show.
Thank you so much, Christine. This was something I'm ashamed to admit I was not even aware of. So thank you for bringing this to my attention, how Canada did change the law. And Christine is correct. The way it stands now is that there is no such thing as life without parole in Canada. And even when you do have life, you don't have sentences like we see here in the US, which might be 75 to life, 50 to life. They have capped that at 25 years, and that everyone is entitled to to be parole eligible after 25 years. So let's talk a little bit about how that happened. And first of all, she references the Alexandre Bissonnette case, which was a case that I remember but was not all that familiar with. This was the case where this man here went to a mosque in Quebec City during prayer time, wearing a ski mask, and opened up fire on everyone inside of the mosque. He ended up killing 6 people and wounding 18 others. And at the time, he was given life, which each term of life for each murder was 25 years. And they could do that consecutively. So I'm doing this a little bit different, but he was convicted of 6 counts of life, up to life, okay, for the murders. I don't know why it was 6 and not, or he killed 6 people. So 6 counts of life. He got 25 to life on each of those. They ran them consecutively. So he was looking at 150 years to life, meaning he wouldn't become eligible for parole until after 150 years. The judge actually sentenced him to 40 years to life. But regardless of that, the Supreme Court in Canada came down and said 40 is too much. They didn't exactly say that, but they said, and this was an interesting quote from them, they felt that any term beyond 25 years, not making someone eligible for parole after 25 years, they considered to be cruel and unconstitutional. And they said that it risked bringing the administration of justice into disrepute. And I think that really does demonstrate a difference from a very philosophical level, in how the Canadians, through their constitution, view, their justice system, and how the Americans in the US view it. Not saying either is right or wrong, but the Canadian Supreme Court at least believes that anything beyond 25 is just unfair. It's just that you are saying that no one is beyond redemption after 25 years. That is something they won't live with. Now, it doesn't mean that person gets out after 25 years. They're eligible for parole, and they could be denied parole. And I imagine this man here, having killed 6 people in this horrific act of terrorism, will be denied parole. And may be denied parole until he dies in prison. I mean, it's still that concept of you're eligible for, but we can keep you for life. So the idea of keeping someone in prison for life still exists in Canada, but the idea of capping someone's or putting a floor on someone's parole is something that they've changed dramatically in Canada. Afton says there are definitely some people who can't be redeemed, rehabilitated, whatever you want to call it. I tend to agree with Afton. I think, and this is just a question, and I'm not even necessarily giving an answer, but it's just kind of a philosophical question that this issue that Christine brings up, I think, raises is, can someone commit a crime that is so evil, awful, unredeemable that they should forever lose their opportunity to live amongst society again? Take the death penalty off of the table. You know, we could have a different discussion about the death penalty, but just the idea that we say to this young man, let's say, Bissonnette, you took the lives of 6 people in a pure act of hatred. You injured 18 others. For that, we have decided as a society, you should live in prison, that you should not live amongst us again. And again, I said it's a question. I tend to agree there might be things like that. I tend to agree that there are things that horrific, that you should just lose that opportunity because of something that you've done. Doesn't mean that you cannot change your ways, think about it differently, rehabilitate yourself, everything else. Still, you took 8 people's lives. 8 people never going to walk the earth again. 8 families never going to be whole again. Is the price to pay for all of that the idea that you just don't get to live amongst us? Well, regardless how we all feel, the Supreme Court in Canada feels differently and feels that at least you should have the opportunity after 25 years, no matter what you've done. So how is it unconstitutional if you will still eligibly be there for life? Well, what they're saying is the unconstitutional part was the stacking, was the consecutive terms, was 25 plus 25 plus 25 plus 25. That's unconstitutional. So when the judge sentenced him to 40 years, I don't know how the judge arrived at that number, but giving him 40 years, that was unconstitutional. The life part of it, in other words, you can commit other crimes while you're in prison, making you parole ineligible, or you can show a lack of, I mean, you know, if after 25 years, this man says, I'm glad for what I did and I do it again, they're going to deny his parole. And if he keeps on coming back that same way, they're going to continue to deny his parole. But if he doesn't, if he's rehabilitated, if he's demonstrated all of that, there may be an opportunity somewhere down the road where, according to Canadian law as it stands right now, he could be eligible for parole and could be granted parole. So that's just how different countries think about things, and different, even states in the US think about things differently. Okay, let me give some thanks to some people here. Sloth Tilica. Not for the stream, sorry, but I'd love to know your thoughts on Scotland having 3 verdicts, not guilty, guilty, or not proven at some point in time. I would love to talk about that, but I have to do a little research. I have heard of that concept, but I'm not educated enough to talk about it. So thank you, and I hope we remember this question because I do want to answer it at some point. But Tracy K gifted a membership. You're so fantastic, Tracy. Misty Peterson gifted a membership. You are fantastic. Lindy DI2, 5 memberships. Thank you so much. Sleth Tilica gifted a membership as well. Thank you guys. Farm Girl gifted a membership. You are all being so fantastic this morning. Seeking Justice became a member, so thank you for that, Seeking Justice. And Sleth Tilica, I think I said this already, gifted a membership. You guys are all super fantastic, and I thank you all for your support. Let's keep it rolling, huh? These are fantastic questions. Look at this. Did you think you would be talking about constitutional law from Canada this morning or afternoon, wherever you're sitting? All right, let's keep it going. Oops, sorry. Christine had more to her question. Wait a minute. Did I do that wrong? No, I didn't do it wrong. Sorry. Moving on. Okay.
Hello, CC crew. It's Joy W. coming from Ottawa, Canada. I just have a comment and a question regarding Bryan Kohberger. I read in some filing that I don't know if he's really diagnosed, but they said he has autism spectrum disorder. And as a parent of an adult child on the spectrum, that concerns me a little bit, just for unconscious bias on the part of the jurors, etc. Yeah, my daughter is intelligent. She finished college, etc. Still socially, she's a little bit awkward. She smiles strangely. She moves, stiffly. She can have inappropriate vocal tone or conversations, and her facial expressions sometimes don't match up with what's going on. So, and with the prosecution, if they're going to use that selfie just to prove that he's got bushy eyebrows, or he did at the time, I think that's fine. But if it's just to show that he, is stiff, he looks weird, he's pale, he buttons his shirt up to the top button, I don't think that is okay, because weird does not equal guilty. And I have no. So this is part two. Sorry, I ran a little bit long. I was saying that that I have no opinion whether Bryan Kohberger is guilty or innocent. But the question for you is, how do you coach a client or try to overcome those kind of things that might, play into an unconscious bias on the juror's part? Or can you? Anyway, that is my question. I do love these Sunday fun days, and I'm always in the chat. Anyway, keep up the good work. Thanks.
Thank you so much, Joy from Ottawa, Canada. This was such a interesting question, and there's been a lot of talk about Bryan Kohberger and this new defense strategy. It's not a new diagnosis, but it's new strategy. They're saying that he should not be eligible for the death penalty because he has autism spectrum disorder. But what Joy pointed out that I had not really ever thought about, and I thought was so interesting, was the use of this selfie here. This is the selfie that the prosecutors have admitted into. They've not admitted it into evidence. They've attached it as an exhibit in one of their motions in limine, but I'm positive they're going to try to have this admitted into evidence during trial, because this is supposed to have been taken within hours of the murders. And they found the opportunity, and I thought very cleverly so, to admit this, because they're trying to, this was about, the question was whether or not he had bushy eyebrows, because one of the eyewitnesses described seeing a person with a mask, but with bushy eyebrows. And I thought, how clever. Now they've got a picture close in time. Does he have bushy eyebrows? But I said, it's also about other things. It's about how kind of creepy he looks, and this bizarre smile that he has, and the giving of the thumbs up, and everything about it. He appears to be in a bathroom, and everything. Yeah, Maureen says it's creepy. All of that. And then Maureen points out the fact that does this perhaps demonstrate aspects of his personality that might be manifesting themselves from autism, from being on the autism spectrum. And I thought, God, I'd never thought about that. How clever. She points out the fact that he does appear to be stiff, that he does appear to have kind of an awkward smile, that he has buttoned his shirt all the way to the top button. And might those be traits of a person with autism? And might that create some sort of unconscious bias in the jurors? And God, Joy, you just brought this up to a different level of things that I had not thought about. Grizzly says, I wonder if he took regular selfies, or was it a special circumstance selfie that differs from his usual cell phone behavior? Also an incredible question, Gizla. And I'm hoping that we get more from what was in his phone, shortly before and shortly after the murders. Yeah. And I'm sure that if this is just one of many, many different types of selfies that he was taking, the defense might even ask to have those introduced. And we don't know why he was taking this, right? It could have been, this was in response to a text message and somebody saying, how you feeling today? And he sends them this picture. I don't know. I mean, we really don't know much about it, because the prosecution just asked to put it in. because of the bushy eyebrows. And I thought, well, if I'm the prosecutors, I'm going to try to show this picture to the jurors as much as possible because of all the other things it's saying in the context of what just took place. But Joy's saying, well, this creates some sort of unconscious bias in the jurors that they just might think him to be weird, or they just might think him because he's on the spectrum. Will they somehow hold that against him? And I thought that was so clever and something I had never thought of. First of all, let's talk a little bit about why autism has even become an issue here. The defense is saying that he should not be eligible for the death penalty because he has autism spectrum disorder. The Supreme Court of the U.S. decided in the case of Atkins versus Virginia that intellectual disabilities make a person ineligible for the death penalty. In other words, if someone is so intellectually disabled, affected that their ability to kind of comprehend, appreciate, be a part of the normal functioning world, those types of folks should not be eligible for the death penalty. The prosecution points out, and many have pointed out, that autism is not an intellectual disability. It is a developmental disability. I am no expert on any of this, so forgive me, guys, if I am not speaking with using the correct vocabulary or whatever it is. But that is the argument being made, that it is a developmental disability, not an intellectual disability, meaning it did not affect his ability to understand or appreciate the consequences of his actions, which is really what the question comes down to. And he was a person pursuing his PhD, and he was a person who was going through, holding down a job and going to school and everything else and functioning amongst society. And I don't think that there's going to be any impediment to the state prosecuting him for and seeking the death penalty against him. Intellectual disability have to be severe, like 70 or less. I think it does have to be something demonstrably affecting that person's ability to appreciate the consequences of their actions, which I don't think applies to Bryan Kohberger. Where it will come up and may be an issue, is in the penalty phase. If we get to that, if he is found guilty and we get into a penalty phase and we're talking about the jurors making the decision between death and life without parole, everything's kind of on the table, including the fact that he has autism spectrum disorder. And I imagine they will try to use that as some sort of mitigation to the jurors. But there's a difference between it being a factor in mitigation. There's a difference between it actually disqualifying him from the death penalty. So I think it will be a factor in mitigation. But to Joy's question, will it create some sort of unconscious bias? I think the answer to that question is I don't think his autism is going to become relevant during the guilt phase. I don't see any reason why that would ever come up. It likely will not be mentioned because for a couple of reasons. One, the defense is saying it's not him. So his autism is not going to play a role with the defense because the defense isn't trying to explain his actions. The defense is saying it wasn't him at all. The prosecution's not going to get into it because I don't think they want to touch it, and I don't think it's relevant. So I don't see any reason why during the guilt phase anyone would actually know about that diagnosis. Now, to take this to its final end, I think Joy was also asking, will people just take a look at this guy in court and maybe have some unconscious bias about his behavior? If he is stiff, if he does kind of behave in a way that indicates some sort of, I don't know what you want to call it, lack of sympathy, lack of eye contact, lack of normal behavior, will the jurors judge him for that? And the answer to that is this. Jurors watch the defendants like a hawk. They always, every time I've ever been in a courtroom, when anything happens on the stand, they immediately 12 sets of eyes dart over to the defendant to see how he's reacting and how he's behaving. And I think they will absolutely be doing that with him here. Will they be judging his behavior? I think yes. Will they be doing that because they believe he has autism spectrum disorder? I don't believe so, but they will, as with every defendant, be likely judging that person's behavior to some extent. All of us hope that that's not exactly what they're going to base their verdict on, but they're always kind of assessing the defendant. So great question, Joy. It had me thinking about stuff I had not thought about before. Psychosaurus Rex says, Josh doing great, or you're doing great, Josh. Thank you for finally listening when us professionals have been screaming that ASD is not intellectual disability. Well, thank you very much. I'm glad that I was able to tread those waters without putting my foot in my mouth. So I appreciate that, Psychosaurus Rex. Barbara North says, is this a trophy selfie? I mean, as the prosecution, I think you're saying absolutely that's what it is. All right, let's move along here to our next question. You guys are doing fantastic. I appreciate all of these. Aren't these great? Yeah, they're great is the answer.
Hi, wrote myself a script because I'm very scared. My name is Madeline. I live in Denver. Josh actually pronounced my name correctly, which is a very rare thing, so A+. My question is, what do you do as a lawyer when you're tired of a case, but you know you still have to work on it? Like there's so many cases and crimes that have happened that are for like 3 or 4 years ago that are just now getting towards trial, maybe. Like, how do you sustain the energy and the empathy and the workload of it all? Thank you.
Oh, Madeline, thank you so much. Madeline from Denver. I love this question. And her question is, do you ever get tired of a case that has gone on forever and you're still working on it? And the answer to that is yes, all the time. It is amazing. You know, when you first get a case, there's this moment of excitement and you're figuring it out and there's all this mystery and you're trying to kind of unwind it. And then with some cases, you're going to court and you're back again and you're back again and you're back again and you're back again. And it's dragging on and it's this never ending fight. And I'll do you one even better. It's as a defense attorney, sometimes you got paid on this thing once at the beginning, depending on what kind of a retainer agreement you entered into. And I'll talk with my colleagues about this all the time, that he'll be like, I feel like I'm doing this trial for free because I got paid on this 2 years ago and that money has long been spent. It's like, now I feel like I'm just doing this for free. And so, yes, it does happen all the time. And you have to kind of maintain some sort of energy and enthusiasm and tenacity and endurance. And it's difficult. I will tell you a story. I had a case early on in my career as a defense attorney. This individual was arrested in May of 2016. He finally took a plea deal in March of 2022. So you're talking 6 years and it had not even gone to trial. It was set to go to trial and we were finally able to settle it before it headed to trial. And some of that had to do with COVID, obviously. Some of that had to do with, we at one point won a motion and the case was dismissed and then they refiled it and it just was back and forth and we had appeals and we took writs and it just was, I mean, I remember at one point we're speaking to the judge and she asked us to approach the bench and there's a stack of papers like this sitting on her desk next to her. And she goes, Mr. Ritter, where are we going with this? Are you planning on filing something else? Because this is all the paper that I have on this case. And I said, Your Honor, if for one moment you expect me to apologize for the work that we've done on behalf of my client, you're not going to get that out of me. The government's going after my client and I'm going to do everything I can for them. And if that ends up being a lot for you to read, then so be it. But it was just kind of these rising tensions, but it was a case that had just lasted forever. So I think of that case when you ask this question, because I was beyond tired. I was exhausted. And by the time it actually settled, I felt like I would almost do the jail time myself just to get the whole thing over with. But we got a good deal for him at the end of the day, and it was worth it to him, and just an exhaustion. This is how long that case had taken place. The law clerk who finished working with me on the case had not even started law school by the time the case started. She started law school, passed the bar, became an attorney, and then was working on this case. And I think I had, how many kids did we have? We had at least one. We got married and had a kid in the time that this whole case took to go from arrest to actually settling it. So that's how long this case went on. But great question. Jody says, Josh, have you ever thought about writing a book about your journey through the justice system and stories or cases? Imagine you have some great stories. I love that idea. I have thought about it. Maybe I'll do it. Kaylin, do you want to help me write a book? Great stuff, guys. I appreciate your question, Madeline, and thank you for calling. All right, let's move along here. Oops.
Hey Josh, it's just Steph here calling from Melbourne in Australia. I'm watching your Wednesday Night Live case updates with Scott, and you're talking about the Lisa Stermer case, and Scott just made a really interesting comment about the defense attorney's tactics to rattle the emotions of the witness to get another, to hopefully get to the truth or to get them off their prepared script. And I was just wondering, Josh, if you have any preferred or favorite techniques that you use when you're questioning or cross-examining witnesses. I can imagine that there's lots of different ways, and that you don't necessarily name them that we don't hear about them as much, maybe because for the defense to protect their strategies and things. But I was just wondering if there was anything that you liked doing in particular that you could maybe shed a little bit of light on for us. Scott's so good as a guest. Like, you don't have to know anything about the case, and it's just so good to listen to him and you guys chat. So thanks so much again. Bye.
Thank you so much, Steph from Melbourne, Australia. And I agree with you. Scott is a wonderful guest. I'm going to give a little shout out to Scott. She is referencing the Wednesday Live that we did with Scott from Recovery Addict not too long ago. It was maybe this last Wednesday, I think it was, where we talked about the Linda Stermer case. We have all of these in our playlist for Wednesday Night Lives. You guys can check it out. In fact, we have all of our Sunday Fun Days in a playlist if you guys want to check out past Sunday Fun Days. But check out this one that we did with Scott from Recovery Addict on Linda Stermer, and he's been following that case closely, and we had a really interesting conversation about it. And Steph is absolutely correct. If you want to know the ins and outs of a case, ask Scott, because he follows them so closely. And I can't thank him enough and shout him out enough. And her question is about, what are the techniques that you use to get a witness rattled? I think is the best way to put her question. Again, I love this question. First of all, I would say one thing I would conscientiously do is not follow a linear timeline in my questioning. If I'm trying to cross-examine someone, first of all, most times in cross-examination, you've got points that you want to make, right? You know that you want them to admit to certain things. You know that you want to get them to testify to certain things. And perhaps you've even identified places where they've told a different story in the past. So you can go back through transcripts and talk about prior inconsistent statements and everything else. And a lot of that can be planned out. But if you're just got a witness and you're not quite sure what to do with them, I would always make sure conscientiously to not follow a linear timeline. In other words, I don't talk to them about tell us about that evening and what happened next and what happened next, and go through all of that. I want to jump around a little bit so they're feeling off kilter and they're realizing I'm the one kind of running the show. And in fact, I'll say that to them. I'll say, okay, well, let's get back to that. They'll answer a question. Maybe I'll like it. Maybe I won't. Maybe, in fact, the way they answered it, I think is fantastic. And I want to exploit that, but I don't want them to realize it in the moment. Okay, let's get back to that. And then jump ahead to something else. Wasn't it true when you told police X, Y, and Z? Okay, let's get back to now the scene of the crime, blah, 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 blah. And kind of keep them on their toes and all over the place. And it's just, all you're trying to do is sometimes exhaust people, sometimes confuse, not in a way that you're being tricky, but in a way that they just don't feel comfortable. But I think the most important thing that makes a good cross-examination, and a skill that most attorneys need to practice more than anything else, is just simply to listen. You've got to pay attention to what they're asking. So many attorneys, you guys can see this, are paying attention to the next question they have to answer or ask that's on their little script, and they're not paying attention to the words coming out of the mouth of the witness. And if you're paying attention to those words, sometimes they're giving you gold. And sometimes they say one little thing that if you ask a follow-up and explore that more, it opens up wide doors to you. And I'll tell you a story. I was prosecuting a case where a mother had been shot to death right in front of her own daughter. And this was inside of a home in a very kind of poor area of town, where it was one of these homes where several people were living in the same home. And, living rooms and dining rooms were being used as bedrooms. And it was just kind of a house full of folks. And the housemate, one of the people who lived there, was testifying on behalf of the defense. And I remember just being very bothered by this person, because it was like, what in the world did they have to gain by testifying on behalf of this horrible guy who had shot the victim and, killed this young woman in front of her daughter. But I didn't really have anything to go on with her. I mean, there was nothing that I felt like I could really go after. She had never spoken to police before. There wasn't like all these prior reports. So I just kept on asking questions, and I just stuck to it. And I just went back and re-asked questions and explored other things, and just didn't give that person an inch until they finally started to break. And they always do, especially when they're not telling you the entire truth, or especially when they're leaning towards favoring one side. It's going to start to show through. And in a moment where I thought this witness is not going to be helpful to us, and it might just be a throwaway witness, and maybe I'll ask a few questions and just cut my losses and get done with it. By the time we were done, I sit back down, and my detective is slapping me on the back, feeling like that was a really pivotal point in our trial. So you never know, but it had to do with listening more than anything, listening to what they were saying. But thank you so much for that, Steph. Great question. And hello to Australia. All right. Oh, sorry, I missed somebody. What did I miss? CJ says, for a Josh Ritter book. Appreciate that. And Beach Bum says, happy to be here. Thank you so much, Beach Bum. All right. Let's move along to our next question.
Hello, everybody. Hi, Courtroom Confidential and crew. I'm so excited we're having this 2 Sundays in a row. I just noticed that, and I was excited. So my question, I'm going to try to keep it very specific, because I know it's kind of a very big issue, and I don't want you to have to do too much homework at all. So this is in regards to Young Thug, the Atlanta trial. The first half, we all know what happened, but now they're trying to revoke Young Thug and bring him back to jail. So my question specifically is, and he's got a good attorney, Brian Steele, but what can Brian do as far as all of his other compadres were, found not guilty? He took a plea deal when he shouldn't have. So is there any way that they can go back and try to get a better deal? Or, is he really stuck with this and potentially going back to jail? Thank you. Appreciate you guys so much. Love you all. Bye.
Thank you so much, Sonia. Didn't know you were such a big Young Thug fan. Appreciate you calling with a question about that. This is a great question, though. You were kind of angry in your question. Well, it's a great question. So here's what happened. Young Thug took a plea deal. You're right. And this was after, you remember, this case with the wheels had come off of this case. They had gone through judges. They had gone through many motions for mistrial. They were, the longest case running in Georgia history. All of this stuff. The case was, a dumpster fire on wheels heading for a cliff. And the defense attorneys used that opportunity and momentum from the judge to try to work out plea deals. And Young Thug got a plea deal. Now, the plea deal let him out of jail. And that was the most important part. But it put him on 15 years probation, which is a very long time to be on probation. And it suspended 20 years prison over his head, which is a lot of suspended time. So just to help you appreciate what that usually means is that for the next 15 years, he's got to walk the straight and narrow. And if he violates his probation, then the judge, per his own agreement, can just enact the 20 years, can just sentence him to the 20 years. No real discussion about whether or not 20 years is bad or good or otherwise. The only discussion is about, did you violate probation? And if the answer to that is yes, then the judge can say, I'm going to order you to serve 20 years prison. So many people refer to this as a devil's bargain. And you see this all the time where these fantastic deals might be offered to someone, but you got defense attorneys telling them, don't take it because this is a trick. They're just waiting for you to screw up somehow in the 15 years. Part of those conditions were he's barred from Atlanta for 10 years. So if he goes to Atlanta, that's even a violation of probation. He's subject to random searches and drug tests without probable cause, meaning a cop knows he's on probation, walks up to him and says, I'm searching everything on you, on your person, and in your car right now. And if they find drugs, they find a weapon, whatever it is, violation of his probation. And no gang associates means he's got to really be careful as to who he hangs out with. So putting aside all of that, we talked a lot about that at the time. He wanted out. He wanted done with this case, and I don't blame him. And that was the deal that he made. And now, in a moment where the DA thought this was chickens coming back to roost, they say that they would like his bail revoked, meaning he's sentenced to that 20 years. The reason for that, though, was kind of chicken poop. And I think that the judge saw that, and I'll explain why. The reason for revoking his bail was that Young Thug posted on social media referring to one of the gang investigators as, quote, the biggest liar in the DA's office. The DA characterized that as him having engaged in conduct that directly threatens the safety of witnesses and prosecutors, compromises ongoing legal proceedings, and warrants immediate revocation of probation. Come on. Come on. I think what this is sour grapes on the part of the DA. They got embarrassed by this case. Everybody thought it was a joke. And now they're trying to find any little excuse, but this is going to be this man's life for the next 15 years. Any little excuse. Pamela says, chicken poop. I'm clutching my pearls. Yes, cover your ears. That trigger warning. I'm going to use some colorful language here. It was any chicken poop excuse to go after this man. And it's just kind of a joke. And how do I know it's a joke? Because the Judge Paige Reese Whitaker, who's the one that gave him the deal, the one that finally brought closure to this whole thing, denied it without explanation. Didn't even have a hearing. Said, I don't even want to hear about this. He is going to be able to jaywalk. He's going to be able to get a traffic ticket. This is not the type of stuff that violates probation and certainly doesn't send you to jail for 20 years. But I'll tell you what, he picks up another crime. He picks up a gun case. He picks up a gang case. He picks up a drug case. anything like that, he's in serious trouble. And she could give him 20 years. I don't know if she actually would, but if he actually picked up a serious crime, some sort of serious felony, I could easily see him getting that 20 years. So great question, Sonia. Thank you so much. Tracy Fagan, thank you so much, says YSL losing his rights to return to Atlanta was the best part of the deal because the DA is gunning for him. Yeah, maybe. Keep him out of there anyways. Smart for him to avoid Atlanta, at least during this current DA's administration. They are coming after him. All right, let's get it moving along here to our next one. Appreciate that, Sonia.
Happy Sunday Fun Day to the CC crew and to Joshua. This is Alicia K. Mayo from West Tennessee. Joshua, my question is, in a case like with Gavin Knupp or the Piketon Massacre Wagner trial, if the judge is retired or quote unquote visiting and the sentence is not agreed upon by all parties, is there any recourse? I mean, what can be done if they're retired or visiting? Thanks. Have a good Sunday. Bye.
Alicia K. Mayo from Tennessee. It always warms my heart to hear your voice. Thank you so much. You asked about the Gavin Knupp case, and I looked that up, and it was a hit and run case. I wasn't quite familiar. I did look it up. We did do some research on it, but I didn't quite understand how it fit into your question, but I think I understand how the Piketon Massacre case fits into your question. This is obviously a huge case that a lot of us have been following for a while, but Judge Jonathan Hine did something in this case that absolutely I felt was unconscionable. And I really try to not personally attack a lot of people. Thank you, Alicia K. I personally try not to attack a lot of people personally on this channel, like defense attorneys, prosecutors, judges. Everybody's dealing with their own issues and everybody's handling things differently. I will criticize actions and everything else, but I was really bothered by the judge's actions in this case, and give you a little bit of background on why I think Alicia K is asking this question. There was a prosecution plea agreement that if Jake Wagner testified truthfully, they would take the death penalty off the table for everybody in that family. Okay, so these were everybody who was charged in this case for the brutal murders of 8 people. Okay, two at 2 different locations, nearly wiped out an entire family in Piketon. George Wagner, George Billy Wagner, Angela Wagner, George Wagner Jr. or Sr., and Edward Jake Wagner. And the deal was, if Jake Wagner, who's kind of one of the most involved in this whole thing, pled truthfully about everybody, then they would take the death penalty off of the table for everyone. The judge said before Billy Wagner had ever even gone to trial that he's taking the death penalty off the table for Billy, and he's sentencing Jake Wagner, and he gave him 32 years, eligible for parole after 32 years. And he sentenced him before Billy's trial. So he took out of the prosecution every ability that they had to negotiate, just ripped the rug out from underneath them. It was, Terry says, this was the far worst judge I've ever witnessed. It hurt my stomach to listen to. I agree. I was really bothered by this whole thing. And the prosecution even said, why are you trying to sabotage this case right now? The judge's answer in part was, the clock is running out. The clock ran out. This case is just taking too long. That is, again, cover your ears, horse poop, in my view, of a reason. You're talking about a case dealing with the death penalty. 8 lives have been lost. You take the time to get justice done correctly, sir. Just mind-blowing to me. But that's what he did. And he did it well within his I mean, nothing that he did was per se illegal. Took the death penalty off the table. These are all within his quote unquote discretion. Took the death penalty off the table, sentenced people beforehand, basically gutted the prosecution's ability to plea negotiate on this case. And he was a visiting retired judge. JC Broadway says it's hot garbage. And what do we know hot garbage is? That is a dumpster fire, because you light a dumpster on fire, you get hot garbage. And Alicia K wants to know, what can you do? What is the recourse for a judge like this? And I think the reason why Alicia K is asking, because of a visiting or retired judge, like, you can't vote this person off now. You can't get rid of this judge. So what are you going to do? The answer is not much. The answer is not much, unless they can demonstrate that this was an abuse of discretion on his part to an appellate court. Not much. If the appellate court believes it's an abuse of discretion, which is not likely because that is such a high standard, but even if they do believe it, they're just going to turn it back down to him. They're going to return it and say, no, you need to make you cannot do what you just did, undo what you just did, and you're still stuck with this judge. This, I think, demonstrates more than anything, first of all, the incredible power that judges enjoy. And by the way, this is the life I've lived for the last 20 years, is how bad judges can be. It was one of the most shocking things to me when I first became an attorney, how many judges out there can be really, really bad. And they have a lot of power and they can do a lot of harm. And this is just one that we happen to have seen on a very big stage in a very big case. But it bothered me. But to answer your question, there's not a whole heck that can be done. If he was an elected judge, you could run against him, you could put somebody up against him, but all of this kind of complaining to judicial disciplinary things, they're just going to say it's within his discretion. Mandy Strong says, does the judge have any connection to the perp? Seems like it needs investigation for possible corruption. I mean, have at it. I don't think there is. I think he's just the judge that doesn't care all that much. And I think in his warped view, he's getting this case moving along. This case has been around too long. I'm going to take care of it. I'm going to, there's been just too much bickering. I'm going to get these things on the road and handle this case. And I'm appalled for what he's put these victims through. But great question, Alicia K. Appreciate you. All right, let's move it on here to our next one.
Hi, Josh. This is Maureen from Monterey. And though I absolutely love Sunday Fun Day, I didn't think I was going to have a question or comment this time, except that I just saw you on Sidebar and you made a comment that I just really disagree with. You said that you thought the defense attorney on the Linda Stermer case was doing an admirable job in defending his client. And whereas I understand that's his job and he is being very aggressive, this man is so over the top aggressive with each witness he crosses. And he is so condescending. And his crosses take so long that he makes me want to drive up to the Golden Gate Bridge and jump off. Except I think they've put up a net and it wouldn't do me any good at this point. That the mere sight of this man absolutely is like nails on a chalkboard to me. So I think if I look at myself as a juror, as an ordinary person sitting on a jury, he's alienating me to the nth degree. He's doing exactly the opposite of what he wants to do. And I'm watching this on Recovery Addict. I've made that comment in the chat. So many people agree with me. I think he's doing a horrible job. So be your best defense attorney and prove me wrong.
There's more to this.
This is Maureen again. P.S. If I can't jump off the Golden Gate Bridge, he makes me want to do my taxes. That's how bad this man, I think, is and how irritating he is. That's all. Bye.
Maureen, Maureen, I wish you could just tell us how you really feel. Just feel free to express how you're really feeling about this one. Maureen, let me tell you this, first of all, and this goes to anybody. Feel free to criticize anything I may say. I mean, if you feel like I've got it wrong, I am man enough and brave enough to hear it. And thank you, Maureen, for calling me out. And she's right. I did say that this attorney, his name is Wolf Mueller. This is the gentleman right here on the Linda Stermer case, that I felt that he was doing an admirable job. And Maureen says she would rather do her own taxes than listen to this man anymore. But here's what I'll say. There is a very fine line to walk. You are doing a high wire act as a defense attorney sometimes to be a zealous advocate on a part of your client and not alienate the jurors. And sometimes that's a matter of taste. And I agree with you, Maureen. I agree that he's abrasive, and he, the whole deal with him smacking himself in the head, and he's done a bunch of other stuff. And I guess admirable was not the right word. Not that I'm sheepishly backing off from what I said. I guess what I'm saying is that the guy's giving it a fight. He's in there punching. He's in there throwing punches, and he's trying, and he's doing the best that he can. And I think my assessment, at least, that the evidence in this case, it's going down like a sinking ship, but he's fighting to the very bitter end. And a part of me says, good on you, sir. That's what you should be doing. Go down swinging for your client. But Maureen makes an excellent point. If the jurors are feeling the same way as Maureen is, then none of this is being really helpful, because one of the best skills a trial attorney can have is just that innate ability. And I don't know if it can be taught or not, but that innate ability to read the room. And you got to be able to tell, are these shenanigans too much? Is this drama in the courtroom too much? Is my snark too much? Am I too aggressive? Am I turning people off? Because you could be doing and saying very effective things, but if your presentation is turning the jurors off, like they obviously did for Maureen, then maybe they're not even listening, and maybe they're not paying attention, and maybe it's not helping you out at all. So excellent point, Maureen. I take that rap on my knuckles with a smile, and I appreciate you calling in about that. Thank you. All right, let's get the next one here. Hold on, we gotta refresh things.
Hi, Josh. This is Christine calling from Langley, British Columbia. Longtime lurker, first-time caller, and this is now the third recording, so it actually is a bit nerve-wracking. But anyway, I actually just paused the sidebar this week because you started talking about something that I've had a question about for some time, and that is about jurors being able to ask questions. I was really surprised to hear that some states allow it and some don't. And I just wonder why more don't, because it makes sense to me that jurors be able to ask questions so that when they're deliberating, they have a much better understanding of the facts of the case. But anyway, yeah, I just would really appreciate your take on that, especially since you're coming at it from two angles, as a former prosecutor and as a defense attorney. So anyway, thank you so much. Really enjoy your show and appreciate all the hard work that I can only imagine goes into putting it out every week. Have a great day.
Thank you so much, Christine from Langley, British Columbia. Really appreciate that question. And I've been thinking about this a lot. She asked the question of, what do I think about jurors being able to ask questions? And I think this is the Linda Stermer case still that we're talking about, where they're able to submit questions. The jurors are able to submit questions to the judge. And the way the judge handles it in this case is not every question gets asked. They submit their questions. The judge reviews them. The attorneys review them. and that decide which ones will be asked of the witness who remains on the stand during this whole process. And then the attorneys get to ask follow-up based upon those questions. And when I first started, because in California where I practice, this does not happen. I've never seen it in court. I have seen where a juror may submit a question on their own, not being invited to, and the judge will usually say, I've received a question, either save them all for the end, or I've received a question that will be answered in due course, or, maybe it's something that doesn't have to do with what a witness testified to. But usually this idea of the jurors getting involved in the questioning of a witness, unheard of in where I practice. And so it made my palms sweaty when I start to see this, because here's where I'm coming from and here's where I'm hopefully ending up. Where I'm coming from is a place where you guys know this now. There is so much litigation done about what evidence will be admissible, what questions are going to be allowed to ask, what questions won't you ask so that you don't open up the door. And as an attorney, you're trying to be very strategic about the way you ask questions. Maybe it's you like how a question played itself out, and you're after the cross-examination, you're letting out this breath of air because it's like, oh, I can relax. We got through that witness without hitting one of the landmines I was afraid we were going to hit. And then the juror gets asked questions and you're like, oh, Lord, here comes the floodgates of trouble I was trying to avoid. That's where I'm coming from. But if the whole point of this is for the jurors to understand what took place, for the jurors to appreciate what the truth is, for the jurors to be the finders of fact, then their questions are probably some of the most important questions to be asked. And the more I thought about this, I thought, okay, well, they get to talk to the judge, so they do get to object to some of these things. They also get to see the questions that aren't asked so that they get an idea of what is troubling some of the jurors. It might be an interesting way for attorneys on both sides to pivot when they're hearing these questions and to understand that this is what the jurors are most confused about, or this is what they're thinking about. And perhaps that means you ask some better follow-up or call another witness to clarify. It's just something I'm not used to and trying to get more used to. But I think end of the day, it probably is a net benefit, because I will tell you this. At the end of a trial, it does seem that the first questions that start to come out from jurors in a deliberation room are stuff that you just never thought of. And you're always amazed. It's like, after all that we did for the last however many days and weeks to go to trial, and the first question they come up with is this, something none of us had thought about. Well, maybe you could have avoided that. Maybe you could have addressed that had you known about that question ahead of time. So I guess the answer to your question, Christine, is I'm warming up to it. But thank you so much for asking. Great question, as always. And hello to Langley, British Columbia. All right, let's move along here.
Hi, Josh. Quick question, and not sure if this is a good question to ask, but I listened to a podcast the other day, and the podcast was saying there was an affidavit in the Bryan Kohberger case brought by the defense that the state was hiding or misleading evidence against Bryan Kohberger. There's someone named Sy Ray that writes software for advanced timing records for cell companies. And apparently a FBI agent went to Sy Ray. He started writing code for AT&T to do this. Apparently the FBI agent came back the next day, said, sorry, I wasn't supposed to give that to you. Well, now there's a paper trail. So apparently Sy Ray is coming out saying that there's a paper trail, that they're lying, that he usually never works for the defense, but in this one case he is. Have you heard of this? And I'm not sure if I'm getting everything correct, but I think that's the basis of the affidavit. Also, just a hypothetical, if something like this were true, if the state was hiding evidence and the defense comes out, what are the implications? Does Bryan Kohberger or somebody else go free? Thanks again. Bye.
Pam, excellent question. And I can see already from the chat that a lot of people are glad that you asked this question. So thank you so much for asking. I'm going to need a deep breath before we answer this one. Do we have, Kaylin, some people to thank? I just didn't want to miss people if we have them along the way. Kana Gray became a member. Thank you so much. Kina, pardon me. Annalie Fitch with a super sticker. Appreciate you. Annalie Finch. Kathy gifted a membership. Appreciate that. Kraken Studio, The Real Booty, gifted 5 memberships. Kraken Studio, by the way, is going to be playing at Coachella this year, so check that out. Tracy Fagan, you could do the whole show on the death penalty. I think you're probably right. Thank you for that question, Tracy. David, is it Abby? I think it's Abby, became a YouTube member, so thank you so much for that. Maureen, thank you for the super sticker. And Tracy K gifted a membership. Thank you so much. Appreciate you guys. All right, Pam. This is a heck of a question. So this issue kind of may be creating more than just a small issue in the Kohberger case. So this gentleman by the name of Sy Ray is a former law enforcement individual. His CV sounds incredible. Okay, he's 20-something years in law enforcement. He started a company called ZX, which is a company that basically does geofencing and cell phone tracking. It develops software dealing with law enforcement agencies to help them track down the cell phones and where they've been going. And one interesting thing, and this is something Pam pointed out, he puts in his affidavit that he wrote. He wrote an affidavit in response to a motion in limine regarding the AT&T timing advance records, and we'll talk about what those are. But he says in there that apart from his work on the Bryan Kohberger case, all of his work has been for the prosecution. So for the defense team, this is a chef's kiss type witness. Former law enforcement, highly respected, seen as a leader in the field, seen as a person that does training on all of this, sets standards and best practices for all of this, and doesn't testify for the defense, is not some sort of a defense, expert that just gets paid to say whatever. He's a prosecution type expert who just happens to be testifying for the defense in this case. So just a golden ticket type expert for the defense. He's being called essentially to impeach, counteract the testimony from who will be the state's witness on the cell phone records, who is Special Agent Nicholas Balance. And this all has to do with what is called timing advanced data. This is not a new concept, by the way. This was around when I was a prosecutor, so it's been around for a long time. And what this is if you think about it, and I'm not going to get too into the weeds on all of this, but if a cell phone pings off of a certain tower, they can time that. They can know how far away from that tower that cell phone is. But if you have one tower, you have to draw a circle around that tower, because if you know it's within, say, 10 miles of that tower, the cell phone, well, you don't know in which direction. So you just have to do a 10-mile radius around that tower, and you know the cell phone was anywhere within that 10-mile radius. Not all that helpful. But if you add another tower, if that cell phone's also pinging off of another tower and a third tower, then you're dealing with triangulation. And when you've got 3 towers that can ping off of the same cell phone, you can get the exact location of that cell phone. And you can then track that cell phone through other towers. As that cell phone moves, it can ping off of 3 or 4 other towers along its entire route. And I've had cases where you can basically, to the second and to the foot, tell where that person was, that cell phone was. After a murder, where did they go? Before a murder, where were they coming from? Incredibly, incredibly helpful information that, like I said, has been around for many, many years. Now, there is going to be a hearing on April 9th, this coming week, where both Special Agent Balance and I believe Mr. Ray are going to testify because, amongst other things, they're going to testify as to who can testify to what. But there's been an issue raised about the disclosure of this data from AT&T by the prosecution to the defense. And this is this affidavit that we were talking, that Pam was talking about. And why is this affidavit causing everybody to kind of get into panic here? And so I'm going to show you this affidavit really quickly. Okay. So this is the defense's notice of filing affidavit in support of defendant's objection to the state's motion in limine. And this, by the way, comes to us through, as the gavel drops, their Discord. They're fantastic. Big shout out to them. So first things, a couple of things to point out here in this affidavit. Page number 3 here. This is the first kind of problematic thing that he points out. He says, this highlighter kills me. I have firsthand knowledge that AT&T was providing the FBI with timing advance reports prior to August of 2021. That is problematic because the prosecution was saying that they did not have anything until, I think, about 2023. But he's saying, I have firsthand knowledge that AT&T was providing the FBI with timing advance reports prior to August of 2021. Then he says, just bear with me here to find this stuff because I had to read through this whole thing to find you the juicy parts, starting with this paragraph here. Come on. What is happening to me? One such email. So he reviewed emails from law enforcement and the DA's office. One such email dated 11/15/2022 was sent to prosecutor Ashley Jennings at her Leda County government email address. This email is from Moscow detective Lawrence Morey. The email is informing Miss Jennings of Detective Morey's recent contact with FBI Special Agent Balance. Special Agent Balance informed Detective Mowry, I'm saying Morey, it's Mowry, that AT&T can provide timing advance data and to make sure it is listed in the search warrant. So he's saying, here's, in fact, the paper trail I can create for you that Prosecutor Jennings was well aware of all of this. He then concludes, starting here, this email is abundantly clear evidence that Mrs. Jennings was not only aware of the existence of the AT&T timing advance in 2022, but also shows her intention to obtain it through legal process from AT&T. Okay? So, what's the problem with all of this? He then goes on to conclude here. It's going to absolutely murder me. It is my expert opinion that AT&T timing advance evidence did exist for the defendant's AT&T mobile device in 2022, and it was requested from AT&T by investigators involved in the case. The investigators previously demonstrated their ability to obtain AT&T timing advance data in 2022. Failure to produce the defendant's AT&T timing advance data is either gross deviation from standard practice or intentionally withheld from release in discovery. His conclusion then being, and this is probably the most salacious part of it, the current motion is a deliberate misrepresentation to the court to further conceal false statements used to obtain probable cause against the defendant and conceal exculpatory evidence from discovery. So that's the problem, is you've got this incredibly qualified individual, according to his CV, who is saying that the government was at best playing very fast and loose, and at worst may have been participating in either deliberate misrepresentations or further false statements. I mean, it's just about as bad as it can get kind of stuff here. His expected testimony is going to be, and this is kind of getting back to, a point aside from this discovery issue, but his expected testimony is going to be that Kohberger's mobile device was south. Well, let's get to that actually later. Gizzle says, come on, what is happening to me? Josh shouts at the document. Haha, my spirit animal. This is going to need to be listen, he's making some very serious allegations here. These need to be handled in court. The judge is going to need to address this. Now, what will be the end result of this? The end result is likely going to be, well, I don't know. This could probably be the defense's best chance at more time, quite frankly. If the defense honestly wants more time and this evidence was withheld from them and the evidence is so important that they need more time to review all of it. Problem is, I think if you're looking at this from the defense's perspective, I think the judge is going to say, well, maybe it was turned over to you late. And maybe misrepresentations were made about what they had and when they had it. But my remedy for that is not to turn this case over, not to exclude the evidence altogether. Those remedies are not, don't address the issue. My remedy would be to give you more time, but I don't feel like you need more time because you've had enough time and you've even had an expert review all of this stuff. If the judge is more persuaded than I'm letting on, then the judge just might give him more time and we might not be having this trial when we're expecting to have it. But if anybody is hoping that somehow this means the cell phone data doesn't come in, I don't think that's happening at all. Or that somehow their experts don't get to testify, I don't think that's happening at all. Or that somehow this issue about the late discovery or the misrepresentations becomes a part of the trial, I don't think that's happening at all either. I think best case scenario for the defense is they get more time. Now, one last thing on Ray is this is his expected testimony. And this is interesting. And I want to point out something about this, though. His expected testimony is that Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho on November 13, 2022. That Bryan Kohberger's mobile device did not travel east on the Moscow-Pullman highway in the early morning hours of November 13th, and thus could not be the vehicle captured on video along the Moscow-Pullman highway near Floyd's cannabis shop. So, if all of this are true, let's say all of that is true and something that he can testify to and prove. What does this actually say? What it interestingly does not say is that Bryan Kohberger could not have been in the location of the murders at the time of the murders. That's what it's not saying. What it is saying is that at best, he cannot be in the vehicle that was captured on video at this Floyd's cannabis shop. And if the prosecution is basing their entire case upon the vehicle captured on video at that Floyd's cannabis shop is the killer, then the prosecution's got problems. The way I think this actually plays out is that either he can't actually produce the goods, meaning Sy Ray, meaning that's not exactly what he can testify to, and they can impeach that, or the fact that that's not the suspect vehicle, or that he's not in that vehicle, plays no role in the murders. And the end of the day, this is a big kind of nothing, and it really doesn't have to do with whether or not Bryan Kohberger could have been involved in the murders. In other words, this would be more interesting to me if he were saying something along the lines of, therefore, during the hours of such and such and such and such, when the murders took place, Bryan Kohberger was nowhere east of the Moscow-Pullman highway, something to that effect. But he's just saying that the video captured is not him. I don't know. we're going to see how this all plays out. End of the day, I think that he's going to be a very, very formidable witness for the defense. It's probably going to be the most difficult part for the prosecution that I've learned of just yet, is how to deal with this guy. Great question, though. Thank you for that. Hold on before I crash my computer. Thank you for that, Pam. All right, let's move along here. Oh, sorry. Hold on. Did you guys not hear any of that? Oh, cripes. Sorry. I'll get this one day.
Hello, I'm a lurker in the channel. You can just call me Momo. I have a question about Karen Reed's retrial and the denied motion to bring the police investigation expert in. So I can totally see the whole not wanting an expert to invade the domain of the jury thing, but my brain wants to dig into this and, being a layperson and not totally understanding, I wonder, is there a line drawn somewhere in the law about when an expert is doing this versus when they need it? Because to me, it seems subjective, but it also seems like the line would be really inherently tied to whether the expert is opining on common knowledge or not. And if I'm remembering right, I think Judge either said or at least implied that this was common knowledge in her denial. So then my question is, during trial, could the defense, to kind of open the door or demonstrate a need for this expert, could they make a point of questioning witnesses on cross about what is common knowledge regarding police investigation and what the schooling education that went into those professions is, and the fact that it requires a unique skill set and things like that? My gut says probably asking lay witnesses what their perception is. This is not okay, but what about the officers and things? Would this be too close to defying the judge's orders? Anyways, thanks for your time.
Thank you so much, Momo. Such a great question. I see you in the chat there. Where are you from, Momo? Let us know. I appreciate you asking this question, because you're asking a question that a lot of people are struggling with on this Karen Reed case. And I think what it is trying to get to understand the difference between somebody being qualified to testify to a subject and whether or not they will be allowed to testify to that subject. So is this special agent, retired FBI special agent Michael Easter, qualified to talk about police investigations? Absolutely. Absolutely. I think he's abundantly qualified to talk about police investigations and to talk about how they should be done properly and how they shouldn't be done and everything else in between. But just because somebody is eminently qualified to testify about something doesn't necessarily mean that the judge will allow that person to testify as an expert, because, you got to take this to its kind of logical end here. We don't want experts testifying as to everything. The example has been used about whether or not it's cold outside. If it's, 10 degrees below freezing outside, and somebody testifies that it was 10 degrees below freezing outside, you can have an expert who's a meteorologist, who's eminently qualified to testify about all things dealing with weather, including whether or not 10 degrees below freezing would feel cold to a human being, whether or not you would need to wear a coat. But do we need that person to testify? And should that person testify? Or is that something that can be argued and the jurors can understand without without it becoming necessary for an expert to testify? And that's what this came down to here. And so, but people, I think, are struggling with that, is that, well, why not hear from him if he knows what he's talking about? Here's what the judge said, and received a little bit of heat for this. I'm not even saying I agree with the judge. I'm saying I understand the judge because I've had judges do this to me many times before. She says, through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures, and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. So first thing to point out is that Cannone is not making this ruling in a vacuum. She saw what happened the first time around. She saw the absolute field day Alan Jackson had with some of these officers about the things that they had done. He made his money on the solo cups and on the grocery bags and everything else, and just had a field day with all of that. And she knows that he can do that here, and she knows that that was very effective. So she's asking, why do you need an expert on the heels of all of that to then come in and say, by the way, it's not standard practice and procedure to have solo cups used to collect blood? She's saying that's unnecessary. And I think that we can agree that that probably is true. He'll have a field day. We can probably also agree that most jurors don't need to be told by an expert that that's not standard practice and procedure, that the officers themselves will testify that it's not standard practice and procedure, and that the defense will have a field day cross-examining all of them. I think what she's concerned about is that if she does allow this expert to testify, will the jurors start to substitute this expert's opinion for their own opinion? They can hear that using solo cups is not standard practice and procedure, and they were used in this case, and draw their own opinion and conclusion from that. But if an expert, an FBI agent, gets up and says that's unheard of and unacceptable, will they somehow give it more weight than they would have in as their own opinion? And I think that's what she's concerned about. But end of the day, Momo asks the question of, can this ever change, and can they open up the door? JC Broadway says, I think the snowblower was even worse than the solo cups. There was the snowblower, there was the solo cups, there was the grocery bag, there was a bunch of stuff, right? Whether or not they secured the scene, all of these things. And the defense is not letting them have an inch of any of that. And they will do that again the second time around. When Momo says, can they ever open the door? And the answer to that is 100% yes. If one of those cops gets up and says, yeah, I don't have a problem with solo cups, I think that's totally fine. I think that using solo cups is totally fine, or that is within practice and procedure, or that using grocery bags is not a problem, and that is within standard practice and procedure. And I don't think that was outside the norm at all. That opens the door. Now we're talking about calling an expert to impeach them. That's a wholly different purpose, and I think opens the door wide open. And believe me, that whole crew right there, you can bet your bottom dollar they're going to be looking for that door to get open. They're going to wait for one of these cops to try to soften the blow, and they're going to say, Your Honor, we need now to impeach that person with this expert. And that door may get opened. Don't be surprised if one of these cops says that. But I think that's where this is all coming from. End of the day, listen, there's people who love to hate on Cannone. Sometimes I think she deserves it. On this one, I don't think she entirely deserves it. Afton says the auditors like the leaf blower. All right, let's move it along here. Great question, though.
Hey, y'all at Courtroom Confidential. This is Holly in Houston, Texas, and I have two questions today. They both regard copyright, but in different ways. And it may be the same at the end of the day. I don't know. That's why I'm asking. So question one, I have been trying to figure out how can I read a book in audio form, i.e. audiobook, and sell it for profit so that I can help contribute to my family's income, because as y'all know, I do suffer chronically, and so I'm unable to work for now. So I can't make heads or tails of any kind of rules or whatever. So if you could please talk to me like I'm 5 and help me understand, I would be so appreciative. Okay, question 2. How is it that people sing covers for songs or even just play covers or play songs and they don't get it taken down? I don't understand that. My son plays acoustic guitar and he's always asking me, hey, mommy, come in here and record me playing this new song I'm learning and send it unlisted to family. So I do that. And while YouTube doesn't take it down, the word copyright does appear next to the video. So I'd like to know why. Okay, thanks, guys.
Thank you so much, Holly from Houston. Good to hear from you always. When I was listening to this question, I am not a copyright attorney. And when I was listening to this question, I told Tiffany, I said, asking a copyright question to a criminal law attorney is like asking your foot doctor, why does it hurt when you pee? I probably have more understanding about copyright or less understanding about copyright than you do yourself, Holly. But I looked it up. I said, okay, well, let me see if I can't look into this, because we've actually dealt with this on this channel, copyright issues. We've had a couple of videos flagged for copyright when we played some news piece in the middle of it and we didn't do it properly, whatever. And so it did bring up some interesting stuff. First of all, how can a person play a cover of a song and it not infringe on copyright? And the answer is you do need a license to play a cover of a song. I didn't realize this. You know, when people are playing cover music, they should be having licenses, and especially if you're recording that, and especially if you're trying to sell that. So you can go get a license. You can license a song and become a licensee of a song and record that song and produce that song. Now, usually these licenses are for very low amounts of reproduction. So in other words, if you want to license a song, cover it, and you can play it, you know, for 100 streams on YouTube, great, have at it. You want to go beyond that, you need to get another license or a bigger license for more streams or downloads of that music. But you can license people's songs and cover them. But YouTube deals with something else because YouTube is video. And this deals with what's called a synchronization license. And that license allows for the synchronization, the syncing of the music with various media outputs, including video. So this is the type of license that a movie might need to play, you know, Thunderstruck by AC/DC in your movie. You need to get a synchronization license from AC/DC to play that. These are much more expensive and not what the average person can go out and get. And these are what you need in order to get copyright license for music on YouTube. So that's why YouTube is always flagging people, because nobody's got these synchronization licenses. The end of the day, though, what YouTube will do is, first of all, YouTube has to realize that it's copyright infringement. So either they're through the algorithm realizing that that music is their music, or you're putting the title of that music in the title of your video, and then YouTube has to realize it and flag it. But usually what YouTube will only do then is demonetize it. So if you were trying to make money off of it, you're not going to make any money off of it. Thunderstruck was not on my bingo card. And then it's up to the artists if they want to, in fact, go after you and sue you, which my understanding is no artists care about what anybody's doing on YouTube anyway. So that is the long story short, or not so short, about copyright issues with YouTube. But thank you, Holly, for that. If you get sued for anything I just said, that's because I'm giving the disclaimer that I really don't know what I'm talking about. And this was just after a little bit of Google searching, but they did not teach this stuff on in law school, to me at least. Next bar quiz, copyright law. Yeah, please spare me. All right. We just got a couple of more here, guys. Thank you so much.
Hey Josh, it's Farm Girl. This Kimberly Sullivan case has got me on my soapbox. The more I learn about it, it's like so many places where the ball got dropped. But my question is, what are your thoughts about more oversight, I guess, over homeschooled kids, such as like an annual visit from somebody? I don't know who it would be, but just to try and protect these kids and make sure they're not falling through the cracks. Curious your thoughts. Thanks. Have a great day. Bye-bye.
Thank you so much, Farm Girl. This is she's referencing the horrible case of Kimberly Sullivan. This is the woman who has been arrested. She had her stepson who was held captive for 20-something years and absolutely emaciated. I think by the time that they found him, he was in his 30s and weighed less than 100 pounds, and he was being starved to death and near the point of death and held captive in a room, and just on and on and on. And it's awful. And he started a fire using hand sanitizer to actually alert authorities to come and save the man. I mean, it's just absolutely incredible. But after we all got past the fog of just what a nightmare this whole thing was, the questions start to roll in, as was a question I had, of why did anybody find out about this? What do you mean that this kid was ripped out of school at the age of 11 and nobody followed up on this? No one had seen from him for years. Family members, nobody asking, no authorities, nobody. I mean, it's just, the more you think about it, neighbors, authorities, law enforcement, school officials, family members, nobody is asking, where is this kid? Why haven't we seen him? Is he alive or dead? What if he was dead? I feel like if he had been there dead for 10 years, it would have been the same amount of action and reaction from everybody else. And so her question, Farm Girl's question, is, what more can be done? How about for a situation where the kid isn't checking in regularly to school? Usually kind of the safety mechanism here is a kid has to go to school. And if they're missing from school, that sends off red flags. If they show up to school with unexplained bruises, that sets off red flags. If they show up to school looking emaciated, that sets off red flags. What do you do if they're homeschooled? The answer is DCFS does check in, does try to monitor these situations. But DCFS, or whatever is the department in the state that you're in, I think in nearly every single state, they're absolutely overwhelmed, understaffed, and underqualified. And at least here in California, my experience is that they always seem to get it wrong. And I do not, if you are involved in DCFS or if you are a person working there, I am not talking about any of the wonderful individuals who work there. I think that they all are trying their level best, but they are dealing with an overwhelming system, and they are probably understaffed and undertrained and not given the resources that they need. But my experience, they would go after parents who didn't deserve it and ignore the parents who did deserve it, as far as the neglect and abuse of children. And it just seems like the system, something is broken. And I realize that I'm saying this without even really providing an answer. But to me, a case like Kimberly Sullivan, it's beyond excuse or explanation. It's just unforgivable. It's just, how in the world does this go on? That to me is almost more, I want the answers to that more than I want the answers to her. She's sick and she's criminal and she deserves what she's going to get as far as prison. But how was no one else aware of this or checking in on this or doing anything to prevent this after decades, to the point that the man literally has to light the house on fire to get a response? Just unimaginable to me. Thank you so much, Farm Girl. Always good to hear from you. All right, we're almost at the end here, folks.
Hey, Josh, it's Dr. Bullbutter here. I'm an OG listener, watcher, whatever. I've been watching and listening since before Courtroom Confidential. I love the way you explain the law. It makes sense, and I just love it. Anyway, big fan, I guess is what I'm saying. My question is about Karen Reed. Since the case went to the Supreme Court and she's looking for certiorari, I think it's called, a writ of certiorari. Do you think they're going to grant it? Do you think they're going to look at her case? What do you think the likelihood of that is, since they get so many cases a year? Anyway, that's my question. Again, it's Dr. Bullbutter here, and I'll be watching. Take care. Bye.
Thank you so much, Dr. Bullbutter. So nice to hear from you. And I have appreciated your support for many years. So thank you. Great question. Again, I am not a constitutional lawyer, but I know a little bit more about constitutional law than I do copyright law, at least. But here's what's happening with Karen Reed and from New Jersey. Fantastic. Thank you. And the writ of certiorari to the Supreme Court. So Karen Reed has appealed her case about as far as she can take it in the state court. She's appealed it all the way up to the Supreme Court in Massachusetts and been denied on these issues. These are all dealing with the issues of quote unquote double jeopardy. The fact that that a mistrial was declared. She's being retried on all of the 3 crimes, but there was evidence that jurors had said that they had agreed that she was not guilty of 2 of the 3, and that they believe that this is now should invoke double jeopardy issues. So there's 2 tracks. There's always, we're always dealing with either a state law or a federal law, and they're different jurisdictions and different court tracks and different systems entirely and different laws. So from the state side of things, she's appealed that and lost as far as she can go. But they also appealed it from the federal side of things because it invokes federal law, because double jeopardy has to do with the constitutional law, and therefore it's federal. It can ask a federal question. So they appealed it to the federal courts. They were denied, and therefore having not received the relief they were seeking in the federal court, they're asking for a petition of certiorari to the Supreme Court of the United States of America. The United States of America, or the Supreme Court, does not have to hear every single case. They have original jurisdiction, meaning they are the final court of redress in certain situations. But these are big situations, like disputes between states. California is suing Oregon, whatever. And this cannot be handled within either one of their state courts, and a federal court, it's in a federal court jurisdiction, and the ultimate court to decide that would be the Supreme Court. Cases involving a branch of government, congressional issues dealing with, the checks and balances between the executive or a legislative branch, big questions like this. And the appeals of lower federal courts can work themselves up to the Supreme Court, but it's on a discretionary level in which the Supreme Court will hear some of these cases, and usually they're incredibly rarely granted. Only a very, very few of these ever get granted that the court will hear it. Usually it requires 4 out of the 9 justices to agree to even hear the case. And what they're looking for is this a case that's important for us to hear because it's asking either an important legal question that has not been answered before sufficiently, conflicts amongst lower courts. In other words, in some courts, they're saying X, and in other courts, they're saying Y, and the Supreme Court's the only court that can resolve that so that we're all operating under the same rules. Or issues of some sort of national security significance, presidential elections, what have you. So you got to ask yourself, does this case, does the Karen Reed case rise to that level? I am going to say no. I'm going to say I doubt that this does. And I realize that it invokes an issue of double jeopardy, which is an important issue, but I do not think that there was something about this case that requires the Supreme Court to come in and give a comment on that hasn't already been commented on both on the state and federal side through their own appeals. And so what will likely happen is that they will deny her certiorari, which means that the lower court, the lower federal court's decision remains in place, which is essentially a decision in itself. It's essentially denying her request for double jeopardy in this case. It was a long shot to begin with. If you read, and we could do that another day, but if you go through the decision that was made as to why she was denied this appeal, it really has to do with what do we consider to be a recorded verdict and what don't we? And it's unfortunate and it's horrible. And I understand the frustration she has and her supporters and her attorneys. But if you're going to get mad at anybody, you got to get mad at that jury, I think. I realize everybody's saying Cannone should have done more, and the attorneys were asking for the mistrial. Cannone was trying to get them to deliberate longer. The only thing I can really point my finger at is those notes. And those notes indicated more than any note I've ever read in my entire life that that was a hung jury. And there was no indication in those notes to me that that meant that they had actually come to a verdict on other charges, but not one of them. So it's unfortunate. It's awful. It's just the way I think it's going to be in this case. But it is also where we're going to have to leave it for this week, because that is everything we've got. You guys have been fantastic. I hope you enjoyed this. I did. Who knew that we would be talking about Canadian constitutional law, copyright law, the Supreme Court of the United States, and what else? I don't know. Bryan Kohberger, all in the same conversation. So thank you guys so much. All right. Couple of announcements. What you missed yesterday, please check it out. We did our weekly roundup here on everything that took place this week. We talked about Ingolf Turk. We talked about Linda Stermer. We talked about Karen Reed and a bunch of other cases, including Rex Heuermann and Lori Vallow. Giving you guys all the updates. Please check it out. It's on our channel now. Coming up this Monday, this is something we're very excited about. We are very we've been looking forward to releasing this to you for a very long time. We did a very special presentation of our Case Notes series. Our Case Notes series is where we take a case that's heading to trial, but not just yet, but it's going to be a big case that we're all following, and we try to do a deep dive into that case and giving you all the background that you need to know on that case. And we did a very special presentation on the case of Bryan Kohberger. And to do that, we actually sat down with Kevin Fixler from the Idaho Statesman, who has been following this case from the very beginning. Kevin is fantastic. He was assigned to this case from the second they knew that the murders had taken place. And he's been in court on the ground, interviewing people, doing everything. So we sat down with him, but we put it together in this entire presentation that we're very proud of and can't wait for you guys to see. That will premiere tomorrow, Monday night at 5 p.m. Pacific, 8 p.m. Eastern. We will be live in the chat with you. There's not going to be a pregame show beforehand, but please join us live in the chat. We're excited for you guys to watch this one. Then coming up, please make sure you like this video before you head out. That's what Tiffany says, and she's the boss. So everybody listen. Then on this Wednesday, we have our Wednesday night live, and we have a new guest for you. It is Linda from It's a Crime on YouTube. She's fabulous. I know a lot of you are fans of her. We've gotten requests to have her on the show. So luckily she's been She's given us some time to talk about the Lori Vallow case that has kicked off. I think opening statements are starting next week. So we will sit down with her on Wednesday and chat about all things Lori Vallow and everything else that Linda is covering. And I'm really looking forward to that. So that is this Wednesday, 5 p.m. Pacific, 8 p.m. Eastern. Donna Tucker says, I love Linda. So do we. So check that out. In the meantime, we're going to try to do another one next week. So leave us those messages. Go to thecourtroomconfidential.com. Leave us a voice message. You guys have all been fantastic. I enjoyed this. I hope you all enjoyed it. We couldn't do any of this without you. We appreciate you. Thank you so much for the support. Thank you for the comments. Thank you for the questions. Thank you for the super chats. Thank you for the gifts of memberships and everything else. I hope that you guys have a wonderful rest of your Sunday, and we will be talking to you all soon. Take care, everybody.